Good morning. My name is Darlene Arnold, and I'm the Director of Producer Enforcement for the Maryland Insurance Administration, and that's in the Compliance and Enforcement Unit. I oversee the Producer Enforcement Unit, which is responsible for investigating complaints received regarding the actions of resident and non-resident insurance producers involving Maryland insurance business. This activity involves all lines of insurance, life and health, licensing enforcement, property and casualty, and also title insurance. The administration is committed to the insurance industry, including agents or producers, brokers and insurers, as well as to the protection of Maryland consumers. A viable, competitive insurance industry is essential to our mission of consumer protection. Our regulatory and enforcement efforts strengthen the environment in which the insurance industry operates in Maryland, and we hope they encourage the insurance industry to find more and better ways to protect the residents and businesses of Maryland. Rigorous enforcement of all applicable statutes and regulations fosters a positive economic environment by assuring that those who comply with the law are not disadvantaged by those who evade compliance. I have with me today Erica Bailey, she's our Associate Commissioner of Compliance and Enforcement, and also our Assistant Chief Enforcement Officer for the Title Unit, Stephanie Ziegler-Palmer. We are here today to discuss Bulletin 1716, which was issued on December 18th of 2017. The administration issued this bulletin as we were receiving inquiries from the title industry and consumers alike regarding Maryland's anti-rebate laws, as certain trends and practices had developed in the title insurance industry, which appeared to violate existing law. We were also receiving inquiries regarding similar bulletins issued by our sister state, Virginia, outlining their laws concerning rebating. We want to encourage a fair and equitable insurance marketplace in Maryland, and to that end, the Commissioner approved issuance of our bulletin in order to clarify insurance law regarding rebating as it pertains to title insurance. We realize that the title industry provides a valuable service to Maryland consumers by finalizing the purchase or refinance of their homes, which for most consumers is the largest financial transaction they will be involved in.
It's just people logging in. Once they all get logged in, it'll go away.
If those of you who are connected by phone could please mute your phone lines. We're getting some feedback here on the webinar. So please mute your phone lines.
Yeah, it's this.
Yeah, mm-hmm.
All right, again, the purpose of the webinar is to review and address concerns regarding Bulletin 1716. The webinar will not address other industry concerns, but we would be happy to discuss other concerns with members of the industry, and our contact information will be provided at the end of the webinar and will be included with slides, which will be provided on our website at www.insurance.maryland.gov. We will also be taking questions posed by the participants and will be receiving those questions via the chat feature for those who are logged in, and for those who are joining via phone, you may email your questions to us at enforcement.mia@maryland.gov. If we're not able to provide an answer to a question posed during the webinar, we will research the matter and respond to you shortly. I'm going to now turn over the webinar to Stephanie Palmer to share the agenda items that we will be covering in today's webinar.
Thank you, Darlene. Good morning, everyone. Welcome, and thank you for participating in this webinar presentation regarding the prohibitions of rebates, discounts, and inducements in title insurance. As Darlene stated, I am Stephanie Ziegler-Palmer, the Assistant Chief Enforcement Officer for Title. You are in for a treat today during this webinar presentation. You will receive informative and helpful information on the following topics. First, we will define what is rebating. Then we will review Maryland's anti-rebating laws as they pertain to title insurance. Then we will explain the purpose of the anti-rebating laws within the title insurance industry. Why do we have these laws? Why are they important? Who they protect? Then we will identify two key phrases within the statute that everyone should be aware of. What are these key phrases? Then we will discuss what activity is permissible, what offers or gifts are allowed to consumers in real estate transactions that will not violate the anti-rebating laws. Then we will briefly discuss the possible or potential administrative actions or consequences for violating the anti-rebating laws and how to report such violations. Then finally, we will answer questions posed by the participants. So, as you can see, we have a lot to discuss today within a small amount of time. So let's get started by first defining what is rebating. What is rebating? I know many of you have already formed or developed your own definition or concept of rebating, but let's explore what the Maryland Insurance Administration defines as rebating. Rebating is the practice of offering, paying, or giving something of value that is not provided for in the policy as an inducement to purchase an insurance policy before or after the policy becomes effective. Rebating can include any of the following. First, refunding a portion of the premium or the producer's commission on the premium to the insured. Second, discounts of premiums not stated within the policy. And third, paying, allowing, giving, or offering to pay, allow, or give anything of value to an insured or an applicant as an inducement to purchase insurance from a specific insurer or producer. Finally, rebates are also incentives in the forms of gifts or other considerations given to induce consumers to purchase insurance coverage other than educational materials, promotional materials, or articles of merchandise with a value of $25 or less. This is rebating in a nutshell. So next, Darlene will review the Maryland anti-rebating laws and title insurance.
Thanks so much, Stephanie. So next, we're going to go into those laws as Stephanie stated, and those laws that relate to title insurance. So let's start. This pertains to actually all insurance other than life insurance, health insurance, and annuities. This is contained within the annotated code in the insurance article with reference to section 27-212. We're going to specifically refer to subsections B and C. B states, except to the extent provided for in an applicable filing with the Commissioner as provided by law, an insurer, employee, or representative of an insurer or insurance producer may not pay, allow, give, or offer to pay, allow, or give directly or indirectly as an inducement to insurance or after the insurance has become effective. One is a rebate, discount, abatement, credit, or reduction of the premium stated in the policy. Two, a special favor or advantage in the dividends or other benefits to accrue on the policy. Or three, any valuable consideration or other inducement not specified in the policy. And C also brings out, an insured named in a policy or an employee of the insured may not knowingly receive or accept directly or indirectly a rebate, discount, abatement, credit, reduction of premium, special favor, advantage, valuable consideration, or inducement described in subsection B of this section. Next, let's look at subsection F. It states, this section does not prohibit an insurer from, 1, paying commissions or other compensation to licensed insurance producers, or 2, allowing or returning to its participant policyholders, members, or subscribers lawful dividends, savings, or unabsorbed premium deposits. Additionally, Section 11407 of the insurance article provides that a title insurer may not make or issue a contract, policy, or guarantee of insurance except in accordance with filings approved as provided in this subtitle, except for special or unusual risks for which a filing has not yet been approved. Each title insurer must hold to the rates or premiums as approved by the Commissioner. They may not deviate from the rates or premiums or allow to or for the account of an insured a rebate, discount on those rates or premiums payable. Finally, a title insurer may pay or allow a commission to a licensed insurance producer of the title insurer as compensation for procuring business. Now next, let's take a look at improper premiums and charges. This is contained in Section 27216B of the insurance article, and it states, a person may not willfully collect a premium or charge for insurance that exceeds or is less than the premium or charge applicable to that insurance under the applicable classifications and rates as filed with and approved by the Commissioner, or classifications, premiums, or rates are not required by this article to be filed with and approved by the Commissioner, exceeds or is less than the premium or charge specified in the policy and set by the insurer. And next, I'll turn it back over to Stephanie, who will discuss the purpose of the anti-rebating laws.
Thank you again, Darlene. So the purpose of the anti-rebating laws, why do we have these laws? Why are they so important within the title insurance industry? Pretty much to ensure that all consumers are treated fairly. Further, anti-rebating laws also prevent the creation of competitive disadvantage or an uneven playing field in the marketplace. Second, they protect consumers from unfair or deceptive practices or discriminatory rates. And finally, they provide market stability by prohibiting insurers and producers from directly and indirectly offering inducements to purchase insurance. So thus, the laws help to create an even playing field, maintain market stability, and protect consumers. So remember this when you are engaging in such activities or reasons for the anti-rebating law. Next, we will move on to what are the key phrases to be aware of within the statute when you are making any offers or gifts to consumers in real estate transactions. Let's move on. The anti-rebating statute has two key concepts to be aware of when offering gifts or promotional items in real estate transactions. The first is paying, giving, or offering anything of value not stated within the terms of the policy or within the filed rate. These can include, or are not limited to, the following examples, which are impermissible: giving or offering free home warranties, free home inspections, Uber rides, Zillow accounts, tax services, legal services, anything of value that is not stated within the policy. The second key phrase is direct or indirect inducement. Direct or indirect inducements include, but are not limited to, the following unlawful practices. It's when the purchase of the insurance is tied to or connected to the gift or the rebate and the volume of the business generated. Next is also side deals that are not included within the terms of the insurance policy and therefore not guaranteed to all consumers or not available to all consumers. Then finally, the rebate or the gift is directly or indirectly contingent on the sale or the purchase of title insurance. So for example, if you offer or give to a consumer or place an advertisement that says, receive a free home warranty with the purchase of title insurance, this would certainly not be acceptable and not permissible and would be a violation of the anti-rebating laws. as you are giving something of value in order to induce the purchase of title insurance. So Darlene will now discuss our next topic of what activities are permissible.
Thank you, Stephanie. Now that we've gone over those activities that are not permitted, let's discuss the activities that are permissible, so which would be an exception. So this states offering or giving away educational materials, promotional materials, or articles of merchandise that cost no more than $25, regardless of whether a policy is purchased. That is permitted. That's contained within the insurance article in Section 27-212D. We know that this cap of $25 will actually increase to $50, and that's effective October 1 of 2018. So let's go on and look at promotional items. Promotional items are a form of advertising which is an attempt to influence consumers to purchase insurance from the producer. We know that this also is utilized to influence consumers to use a particular title agency for their real estate closing. Anti-rebating laws do not prohibit insurance carriers or producers from advertising products and services or offering promotional items or gifts whose value is $25. And of course, we know that increases to $50 October 1 of this year. It says or less to consumers. However, the promotional items cannot be connected to the purchase of insurance or an inducement to purchase insurance. The promotional items must be offered to a consumer whether or not the consumer purchases a policy. So permissible or promotional items could include the following. Of course, you can offer mugs with your company's logo imprinted on them. The same with pens or calendars. Also gift cards, as long as they do not exceed the accepted amount. $25 currently, that increases to $50 October 1 of this year. All right, now I'm going to turn it back over to Stephanie to discuss settlement fees, reduced or discounted fees.
Thank you again, Darlene. Another example of allowable or permissible activities under the anti-rebating laws in Maryland is offering or giving reduced or discounted settlement fees to consumers. The Maryland Insurance Administration does not regulate settlement fees. That's right, the MIA does not regulate the settlement fees, as these fees are not filed with the Insurance Administration, except if, 1, the settlement fees are contingent upon the purchase of title insurance. 2, the discount settlement fees should not create an obligation for the consumer to purchase insurance. And finally, the reduced or discounted settlement fee should be offered to a consumer whether or not a policy is purchased. For example, if you receive a phone call from a consumer who's shopping around for the best settlement fees, and the consumer informs you that they have contacted Title Company X, and Title Company X is willing to conduct their settlement at a particular cost or set fees, and they inquire whether or not your company can match or beat those fees, you are certainly able to negotiate your settlement fees with that consumer in order to give that consumer the best benefit or rate for settlement services. This would not be a violation of the anti-rebating laws. This would be an example of giving reduced or discounted settlement fees as long as they're not contingent upon the purchase of title insurance. Next, let's discuss potential or possible consequences for violating the anti-rebating laws. Whether or not a given activity is a violation of Maryland's anti-rebating laws will be fact-specific and will depend upon the circumstances. The MIA may conduct an investigation that may result in the initiation of the appropriate administrative action, which could include any of the following: a denial, suspension, or revocation of a license for a producer or an applicant for a producer's license. Could also be an administrative penalty, not less than $100, but not exceeding $500 for each violation of the insurance article, and or restitution to any consumer financially harmed by the activity. Please refer to Section 10-126 of the insurance article for further information or reference. Now that we've discussed the possible consequences for violating the laws, let's talk about how you can report any violations that you may become aware of. First, you can send inquiries or concerns regarding this webinar or other title-related issues to our email address at enforcement.mia@maryland.gov. Second, you can submit complaints online or by mail to the Maryland Insurance Administration at our address on St. Paul Place. Also, you can use those phone numbers there that have been provided to make inquiries or calls as needed. Then finally, always visit our website for additional information and assistance. Now we will have Darlene discuss with us about the resources that may be available.
Thank you, Stephanie. We've provided numerous resources here in order for the participants to consult these resources if they have questions. Of course, we are also available to discuss with the participants any questions or concerns they may have. One of the resources, of course, is our Bulletin 1716. The next is a real property article site, Section 14-127, that deals directly with real estate settlements. We all are familiar with RESPA and the requirements, as well as the Consumer Financial Protection Bureau and the requirements that they have. And also the administration has on its website a brochure entitled Consumer Guide to Title Insurance. Next, we'll go through the reminders of what to do and what not to do. First, we're going to deal with those items that are prohibited, or activities, I should say, that are prohibited. We would not want to give or offer anything of value to directly or indirectly induce the purchase of insurance. We would also not want to offer or give anything tied to the purchase of insurance. We would not want to offer reduced settlement fees contingent upon the purchase of title insurance. And an important note regarding that is not conditioning home warranties or inspections on the purchase of insurance, or offering the warranties and inspections to all, and not increasing your settlement fees. These activities are still unlawful rebating and are activities that are prohibited. So the next column over here, and what we would want to do, you do want to continue to provide consumers with optimal customer service and superior products. We want to provide consumers with a fair and equitable marketplace. And we also want to limit the value of these educational, marketing, or promotional items to the amount of $25 currently, and that to increase to $50 effective October 1 of 2018.
So let's kind of take a break, take a breather. We've gone through a lot of information. Hopefully you're still with us, still on topic, understand what we're addressing here. Also, you have found the information thus far informative and helpful, and some of the information has provided assistance in addressing any concerns or questions surrounding bulletin number 1716. And also you'll have some takeaways at the end of this webinar presentation. So before we get into questions, just a note. This webinar and any answers provided to questions posed by this webinar, or during this webinar, are intended solely for information purposes. The information and the answers are not intended to set forth legal rights, duties, condone or approve any particular activity or business model, or give or offer legal advice, or be a substitute for legal advice. Please consult with your attorneys as needed. So, prior to the webinar, we received several questions which we will address first. So the first question that we received is, have any changes been made to the regulations regarding affiliated business arrangements? Answer, the Maryland Insurance Administration does not regulate affiliated business arrangements. So please consult the appropriate statute and laws for further assistance. The next question, Is a courtesy credit allowed for repeat customers? The answer, yes. As stated during the webinar in slide number 16, producers may offer reduced or discounted settlement fees. Such practices would not be viewed as a rebate as long as the credit does not change the premium or other filed rates. So let me state that again. It's acceptable as long as it does not change the premium or other filed rates. The next question. A title producer receives a communication from a consumer stating that the settlement of another title producer is $250 less, and if the title producer will match the other producer's settlement fee, the consumer will settle with the title producer. The title producer matches the other title producer's settlement fee, and this discount is given whether or not the consumer purchases title insurance. Does this discount violate Maryland law? Answer, no. As provided in slide 16, producers may offer reduced or discounted settlement fees and negotiate fees with consumers without creating an obligation to purchase title insurance. So it should not create an obligation to purchase title insurance. This is not a rebate and would not violate Maryland anti-rebating laws. Please keep in mind that you may not reduce your commissions or part of your premiums in order to give a discounted settlement fee. Darlene will address additional questions.
Thank you, Stephanie. All right, additional questions we have. Title producer provides the following volume discount to consumers. If a consumer retains a title producer to perform more than 4 settlements per year, the title producer's settlement fee is waived, and the title producer performs the settlement charging actual costs only. This discount is given whether or not the consumer purchases title insurance and is given to all consumers who meet the criteria. So, for example, it's the title producer's fee structure. Does giving this discount violate Maryland law? Answer, no, it does not. As stated also in slide number 16, title producers may offer reduced or discounted settlement fees. This is not a rebate and would not violate Maryland law as long as the discount is not contingent upon the purchase of title insurance. All right, next question. A title producer offers a $50 discount to all consumers who perform future settlements with the title producer on the same property involved in the transaction. The discount is given whether or not the consumer purchases title insurance and is given to all consumers who meet this criteria. Again, it's the producer's fee structure. Does giving this discount violate Maryland law? The answer, no, it does not. A title producer may discount their settlement fees, again, as long as they are not contingent upon the purchase of title insurance.
Continuation of questions. The next question. For marketing purposes, a title producer regularly appears at a real estate broker's offices and gives free seminars on real estate topics. The title producer also answers questions from real estate agents who contact the title producer by telephone or email without charge. These activities are performed for all real estate agents, whether or not the real estate agent refers business to the title insurance producer. Does this activity violate Maryland law? The answer, no. As provided in slides 14 and 15, title producers may offer or give educational and promotional materials that cost no more currently than $25, which shall increase to $50 as of October 1, 2018, and the seminars and information are not tied to the purchase of insurance. This is not a rebate and would not violate Maryland law as long as these are not offered as continuing education credits, because as we know, continuing education credits or classes have a value and a cost and would certainly exceed the statutory limit. The next question. A title producer attempts to give consumers significant savings by applying the reissue rate to consumers if the producer is able to provide or obtain proof of a prior policy. However, there are times the prior policy is not attainable or not available for various reasons. Thus, in order to level the field, the title producer discounts the settlement fees to the consumer. Does this discount violate Maryland law? Answer, yes, as the reduction in fees is directly related to the purchase of title insurance and would constitute a violation of the insurance article.
Thank you, Stephanie. Well, those are actually the questions that we received in advance of the webinar. What we'll do now is look at the chat feature. If then any of the participants have additional questions that they would like to ask. So what we'll do now is look at that chat feature and see if we have any additional questions posed. And those will be questions in addition to the items that we have addressed already regarding the webinar. So let's look at those questions now. And all those of you who are logged on, you'll be able to see those questions posed. Again, if we can answer them today, we'd be more than happy to. If, however, we need to research a matter, what we will do is research that matter and respond to you shortly. So let's take a look at those questions in the chat feature. Again, our computer is working on those. Please bear with us. I see a question from Matt. Is it Celentano? I hope I'm not mispronouncing your name. He asks, would it be possible to send around the slide deck by email to participants? We will be providing that on the administration's website at the conclusion of the webinar. And again, we have, what if the settlement service provider reduces their settlement fee to $0? I believe we addressed that in one of our answers to questions that were already posed. If the settlement service provider is charging actual costs, to charge actual costs is provided. To do the settlement for free is not, because we know that, of course, an abstract costs money. We know that other items regarding the performance of the duties of a title company actually incur costs. So to do it for $0 for a closing would not be permitted. If your fee is going to be reduced, your fee can be reduced. However, the settlement itself in its entirety will not be able to be performed for free. All right, let's look at another question. We're competing with quotes from other settlement service providers who are also producers, where the discount they offers in a free settlement fee. If there are situations like this you'd like to refer to us for review, please forward them to us via that email box at enforcement.mia@maryland.gov. We may need a bit more information than what's contained in this question. And again, we have another question about the slides being available. Again, they're going to be posted at the conclusion of our webinar. It asks again, where on the MIA website will the slide deck be posted? It's going to be on our main page at www.insurance.maryland.gov. I have a question about explaining our paragraph on the bottom left side of slide 19. Okay, are you referring, I believe it's to the notes section about home warranties? Offering home warranties would be a violation. If you're offering to pay for a home warranty or for an inspection, because it would far exceed the allowed amount of $50. You're looking at a home warranty, which usually runs between $400 and $500. That far exceeds the $25 amount currently, and then the $50 amount that will be allowed effective October 1. So that would be considered a rebate. So we're looking at the next question about if a real estate company owns a title company and the real estate company offers a free home warranty. Well, the Insurance Administration does not regulate the realtors or the real estate company. However, that cannot be reflected on the settlement statement. If the title company is involved in providing that rebate, that would be considered a violation. Okay, we're looking at the next question here. And please understand, if we cannot answer a question or we may need to do additional research, we're going to do that and then respond to these in a short period of time. I believe this next question is very similar to one that we just answered. We have now a realtor who owns a title company and then offers a home warranty with the use of their title company. This particular matter would be viewed as a violation because it is connected to the title insurance company. This next question deals with, can an agent offer to make charitable contribution in a consumer's name to a registered charitable organization of the consumer's choice? I actually would need to research this matter. So this is one that we'll research and get back to Mr. Moran. Sean Moran, I believe, posted this. So we will have to do a little research regarding it and get back to you. Also, the next, can a settlement agent refuse to close a transaction? The buyer in a cash transaction declines to purchase title insurance. I believe that that would be a business decision on the part of the title company. Again, just to be clear, I will research this matter and respond with an answer. And then we have a question from Rick Harvey regarding the difference between a producer reducing their settlement fee by $300 or purchasing a $300 home warranty for the consumer. What I'd like to do is research that matter and get back to you if possible. We have another question about education being limited to $25. Would this prohibit us from paying for CE classes for real estate agents? Again, with that question, I would like to research that matter and get back to you. I have a question from Jeffrey Thompson regarding title insurers provide education at no cost to their producers to keep them abreast of current developments and to refresh their recollection of practices. Is there a need to quantify the cost of providing these classes? I don't believe that there is. If the title insurer provides it at no cost to their appointed producers, there would be no need to place a value on that or on those classes. Question we have, does MIA monitor title company advertising for offers that are not in compliance, or does it depend on complaints to take action? The administration receives complaints and information from a variety of sources. So when you say, does it monitor title company advertising, we do not monitor the advertising. It normally is reported to us if the individual reporting feels that it's problematic. Next question asks, your presentation consistently refers to the purchaser as a consumer. Is there an exception or inapplicability for strictly commercial transactions? I do not believe so, but again, we'll research the matter and we'll get back to you. And will we publish answers to all questions being researched so that all participants may know the answer? I believe we will, yes. And we have here, are attorney agents held to the same criteria relating to rebating? Absolutely. Attorney agents are producers in their role here at the Insurance Administration, so they're held to the same criteria as any other producer. All right, it looks like we've reached the end of the questions that we have, that we've received from the participants. As I stated, we will get back to you with answers to those questions we were not able to answer, and that where we need to do just a little bit more research. I understand that our commissioner, Al Redmer, would like to make some comments, so I'm going to turn the webinar over to Commissioner Redmer.
Good morning. On behalf of Commissioner Redmer, my name is Erica Bailey, Associate Commissioner for Compliance and Enforcement. I'd like to take this opportunity on behalf of Commissioner Redmer to thank all of you for your input, your questions, and your attendance in this webinar. We will make every opportunity to make ourselves available in the event that any of you have any further questions. And again, thank you for your time.
Well, thank you all for participating in the webinar. We hope the information helps to clarify any concerns you have. Again, you have all of our contact information that's presented on the screen. So thank you so much for your participation, and this will conclude our webinar. Thanks so much.
Thank you.